Mr. Chair, and I know this is the one that everybody's been waiting for, and I don't expect to be as successful as I just was. But anyway, having said that, House Bill 609 is not new to anyone. However, this version is a little different. Quite simply, this removes the ability of any government actor to use sovereign immunity as a defense when a person's constitutional rights have been violated. This allows Virginians to take advantage of both either the state court or the federal court when their constitutional rights have been violated. And it would increase accountability, transparency, and make sure that we are getting the best from the people who are sworn and required to protect us and serve us. Earlier versions have really limited this to law enforcement situations, but we have said what's good for one is good for all, and if any government actor violates a constitutional right, Virginians should have the right to sue and have that case be heard without it being dismissed solely on a procedural defense. And so there are a couple things in here. We've limited any personal or individual liability to $10,000. And I think that's the big change. The two big changes are one, that it caps individual liability, and it applies to all government actors. I have been privileged and honored to work with some law students at University of Virginia who are extremely bright, intelligent, and I would like to invite Kate up here, who's been wonderful, and she's my phone a friend and expert on this.
Thanks, Delegate Bourne. Good afternoon, Mr. Chair, members of the subcommittee. My name is Kate Cutchy. I'm a student at the University of Virginia Law School's State and Local Government Policy Clinic. I, along with another student, Josh Hassell, have worked with Delegate Bourne to research and draft this bill. The views I express today here are my own, not the universities or the law schools. Virginians should be able to hold the government liable when it harms them and when it violates the Constitution. However, this unfortunately almost never happens. Let me give you 3 examples. When citizens were thrown overboard while a harbor patrol employee tested a new boat with dangerous high-speed turns, the government was not held liable for its employees' actions. When a county-run nursing home failed to treat an elderly patient and he died, the local government escaped liability. And when a student was instructed to use a defective table saw in shop class, injuring his hand, he did not recover damages. None of these real Virginia plaintiffs succeeded in lawsuits against the state or local government, even though they suffered serious, sometimes life-altering injuries. And this is because of an outdated court-created doctrine called state sovereign immunity. HB 609 fixes this. It'll allow victims to be made whole by removing the defense of sovereign immunity. Citizens can sue the state and local government for constitutional violations. They can also sue for negligent hiring, training, supervision, or retention. Now, some of you may know this, but state sovereign immunity is not the same as qualified immunity. Qualified immunity is a federal doctrine created by federal courts, so this legislature is not in a position to change that doctrine. This body is, however, in a position to fix state sovereign immunity. HB 609 is necessary to limit the defense of sovereign immunity for 3 main reasons. First, it's an outdated doctrine created in the early 1900s. It comes from old English common law designed to protect the king because he could do no wrong. And the legislature should look at this doctrine and ask whether it serves Virginians today. Second, the doctrine is difficult to apply even for the smartest thinkers on our courts. In fact, the Virginia Supreme Court has said about this doctrine, quote, "No single all-inclusive rule can be enunciated or applied in determining entitlement to sovereign immunity." Plaintiffs deserve more certainty than that. And finally, as I pointed out, victims are often left without a remedy. The Virginia Constitution says that the best form of government is one that guards against maladministration. But when there's maladministration, when the Constitution has been violated, what then? As the law currently stands, citizens rarely recover. The government often gets a pass. If respect for the Constitution is important to you, if government accountability and making victims whole is important to you, then I urge you to support this bill. Allow Virginians to hold the government liable when it violates the Constitution.
Thank you. Anyone here? Well, Delegate Anderson, you have a question?
One question for the patron. Delegate Bourne, does this bill waive absolute immunity of legislators when we pass unconstitutional laws that require the citizens to have to go to court to declare those unconstitutional?
Yes. I've been advised by my expert, rightfully so, that there are judicial and legislative exceptions.
So again, we find a bill that exempts us gives us absolute immunity, but asks law enforcement in other areas to waive their immunity. That's where we find ourselves once again. Is that correct?
I would say that the bill is what the bill is, and that there is judicial and legislative exceptions in the bill.
Anyone wish to speak in favor of the bill?
Yes, Mr. Chair. Mark Dix on behalf of the Virginia Trial Lawyers Association, and we support the bill as we have past efforts. And in the new version of the bill, it makes it very clear that the employing agency is responsible. And as we've stated before, if we're going to stop the constitutional deprivations, we have to hold the employer responsible for those. Thank you.
Thank you, Mr. Dix. Anyone else in support of the bill here? Yeah, I know. Anyone in opposition to the bill physically present?
Oh, yeah.
Mr. Chairman, members of the committee, I'm Elizabeth Hobbs, representing the Virginia Sheriff's Association, and we oppose this bill. This bill eliminates sovereign immunity for, as it's been pointed out, all public employees as well as public volunteers, with the exception of giving immunity to judges and legislators. That opens up certainly our law enforcement community, but also prosecutors. It opens up jurors, opens up the folks who work in our schools, people who work in our highways, all public employees and public volunteers. The law enforcement community, full of deputy sheriffs, 9,900 members of the Virginia Sheriff's Association, are extended, they're understaffed, and they receive $35,000 a year. So even a cap of a $10,000 exposure for a sheriff's deputy is nearly a third of his or her annual salary. This bill is a detriment to certainly the law enforcement community, and our association opposes it.
Mr. Chairman, members of this committee, my name is Dylan Bishop. I'm here on behalf of the Virginia Law Enforcement Sheriffs as well as the Virginia Government Employees Association, which represents the interest of the Commonwealth's 122,000 state employees. This bill, I think I heard one of the speakers say that this bill would only hold the public agency accountable, but there's a line in the bill that says that the public agency and the employee will be held jointly and severally liable, and the public employee, his or her liability shall be capped at $10,000. We're in a period of unprecedented recruitment and retention issues, both in our law enforcement community and with our state employees. This legislation, if passed, would only exacerbate that problem. These are dedicated public servants, and we ought to assume that they're all acting in the best interests and with goodwill. So we think this is a move in the wrong direction. It would be a detriment to our public safety and our state's workforce. So we encourage you to not pass this bill on or recommend reporting it. Thank you.
Thank you, Mr. Bishop. Mr. Huggins.
Thank you, Mr. Chairman. Wayne Huggins, representing the State Police Association, and we are, as we have been for the last couple of years, categorically opposed to this bill. Contrary to what has been stated, law enforcement, when I was the sheriff of Fairfax County and later the superintendent of state police, I have been sued many times in those capacities, and law enforcement does in fact lose lawsuits. It's just as simple as that. So this notion that somehow we can go out and act with impunity and not be held liable for our actions is totally false. As has been stated, and without being redundant, we are facing a major crisis in law enforcement in attrition. and retention and recruitment. State Police currently has right at 300 vacancies, and we're having a very, very difficult time recruiting. And these kinds of assaults on law enforcement are one of the reasons why. And we very, very much would like for you to kill this bill. Thank you.
Good afternoon, Mr. Chairman and members of the committee. My name is Ken Shibman. I'm with the Virginia State Police. I'm just going to basically echo the comments of the previous speakers in opposition to this bill. We just ask that you do not pass this.
Thank you. Mr. Martin.
Good afternoon, Mr. Chair, members of the committee. Dominique Martin, Policy Analyst for Virginia Majority. We thank Delegate Bourne for bringing this bill and being an advocate for this issue. We do believe that this is one of the vehicles to achieve more accountability for the community with regards to law enforcement actions and the ability of citizens to seek redress when their rights are violated. And so for that and the reasons stated by both the patron and the advocate, please pass this bill. Thank you.
Thank you. Mr. Schweikert.
Thank you very much. My name is Jay Schweikert, and I'm an attorney and research fellow with the Cato Institute's Project on Criminal Justice. My primary focus for the last 4 years has been accountability for law enforcement, especially with respect to the doctrine of qualified immunity. Now, as has been stated, this qualified immunity is a defense under federal law. It's not currently a doctrine under Virginia law. But the fact that qualified immunity is so effective at preventing meritorious lawsuits from going forward on the federal side reinforces why it's important for states to ensure that there's a viable means of holding police officers accountable as a matter of state law. I think what would be most helpful is actually for me to address several of the points made by the representatives from law enforcement organizations that spoke previously, particularly the idea that bills intended to ensure accountability are somehow an assault on law enforcement or are hurting law enforcement retention and recruiting. On my view, I think that gets the analysis exactly backwards. I think it is absolutely true that we are facing an unprecedented crisis of accountability for law enforcement in this country. And I'm very sympathetic to the overwhelming majority of professional law enforcement officers who strive to do their jobs with respect for the citizens that they police, who feel that they are being unfairly tainted by examples that are blown out of proportion in the media. And I can understand the frustration at feeling like officers are being stereotyped. I think that is exactly the reason why ensuring accountability for members of law enforcement is all the more important. Because right now, doctrines like sovereign immunity under Virginia law and qualified immunity under federal law prevent law enforcement officers from being held accountable when they violate people's constitutional rights. And that hurts not only the victims of police misconduct, but officers themselves, because it deprives them of the public trust and accountability, of the public trust and respect that they need to do their jobs safely and effectively. Police simply cannot do their jobs well when they don't have the trust or respect of the communities they police. They won't have the cooperation of the citizenry in reporting crimes. And when the average member of the community is hostile to police officers, that raises the risk of any police-citizen encounter. So ensuring accountability for the small minority of officers who do violate people's rights is something that will benefit professional police officers as much as anyone. So while the Cato Institute is not testifying in support of or opposition to any particular piece of legislation, we do think it's absolutely essential to ensure accountability for all public officials, but especially members of law enforcement. And that is for the benefit of law enforcement as much as for the rest of the community. Thank you very much.
Thank you, Mr. Schweikert. Mr. Neely.
Thank you, Mr. Chair. My name is Keith Neely. I'm a proud alum of the University of Virginia School of Law, and I'm currently a practicing attorney at the Institute for Justice in Arlington, Virginia. We are a libertarian nonprofit law firm that litigates constitutional cases all over the country involving First Amendment free speech, property rights, economic liberty, school choice, and of relevance to today's discussion, government accountability generally. And we are in strong support of HB 609. And I wanted to direct my testimony specifically to the state of Virginia law as it is today, because as it stands now, Virginia law provides little to no remedy for Virginians whose constitutional rights have been violated by employees of the government. The Virginia Tort Claims Act, although it does provide a narrow waiver for actions provided by some state employees, does not apply to municipalities, does not apply to towns, does not apply to local government entities. And the result is, unfortunately, that most Virginians do not have an effective remedy when their rights have been violated. In my written testimony, I submitted as an exhibit excerpts from a recently released IJ report entitled 50 Shades of Government Immunity, where we research and study state immunity laws all over the country. Virginia, relative to other countries, states received a grade of D, which is candidly abysmal. The HB 609 that the committee the subcommittee is considering today would elevate Virginia to a grade of A-, which would tie it with New Mexico as leading the nation in providing remedies for people whose rights have been violated. Previous speakers have already addressed some of the comments in opposition to today's legislation quite adequately, so I won't spend any more of the subcommittee's time on those points, but I would be happy to answer questions based on my expertise in this field if the subcommittee has them. Thank you.
Thank you, Mr. Neely. Ms. Knoyton.
Good afternoon. My name is Gayleen Knoyton, and I represent the Virginia NAACP. And we are strongly in support of this bill, HB 609, for the simple fact that police brutality goes unpunished and it denies victims their constitutional rights. Thank you.
Thank you, ma'am. Delegate Bourne.
Thank you, Mr. Chair. I think you've heard from some folks who you might not have imagined ever standing up with Delegate Bourne supporting one of his bills or one of the concepts. But I do just want to address a couple things. One, we talk as if we are talking about a simple slip and fall event at a government building or a rear-end car accident. We're talking about violating constitutional rights, clearly established ones. One, that's the first thing. And two, to the general proposition, I've been at this bill for several years now, and I've done with this what I try to do with all the bills that are not successful the first time, is I try to listen, review the testimony both for and against, and try to course correct and work with the stakeholders to try and get to a happy place where we can all agree that something is appropriate to move forward. I think I've done that. This reflects ongoing conversations. We started out with no cap on individual damages. We're now down at 10,000. And what's more is we even have, if you just as an example, lines 42 through 50, that removes the individual employee liability if, in fact, any of these criteria are met and places that liability solely on the employer. So again, Mr. Chair, it would be my hope that we can move this forward to increase accountability, increase transparency, and really begin to give folks who have their constitutional rights violated by government actors some sense of redress.
Thank you, Delegate Bourne.
Second.
That's your motion. Motion to lay the bill on the table. Is there a second to that?
Second.
Motion is second. All in favor signify by their vote on the machine.
Will you hit no for me, Patrick, in case there was a question?
Bill would, the motion to lay it on the table would pass by a 5-3 margin. Thank you,
Thank you,
Delegate
Mr.
Bourne.
Chair. Thank you.